Good morning, Judge King.
Good morning, ladies and gentlemen.
Sir, I got Terrence Toole and Andre Scott on the 8th floor.
Andre Scott, who's the other one?
Terrence Sewell.
Okay, first up, let's have Mr. Nosey. Good morning.
Morning, Judge. How are you?
Good. You here on board?
Yes, Judge. If the court would indulge me, if you could forward me a copy of the tether violation report.
Yes. Let me know when you're ready.
Actually, I haven't received it, Judge. Did you need my email address?
We have it.
Oh, look who's here.
Sure.
You doing?
Hey, how's it going?
Okay, Judge, I've reviewed it. My client obviously is in custody.
Let me
Do we
call
know-
the case. Let me call it.
Calling case number 2305-633901. People of the state of Michigan versus Brian Moore. Defendant is charged in count 1, aggravated indecent exposure. Sexually delinquent person notice, indecent exposure. Defendant has a habitual offender or offender notice.
Appearances for the record, please.
Eric Gozi on behalf of Mr. Moore.
All right, let me get the number. Oh, I think it's a number.
Okay, so the defendant is before the court on a tether violation. Apparently, he was placed on house arrest and was not in compliance. How would you like to proceed, Mr. Dozy?
Judge, Mr. Moore needs to be present. I believe he's in custody over at the Division I jail, so that he and I can advocate on his behalf. I did speak with Mr. Moore briefly about this on Friday without having the benefit of having the report, and he gave me a gist of what it was said. I just received the report just a few seconds ago, so I would need to have a breakout room.
Division 1, 6th floor.
Yes, Judge, we're getting him. He'll be in the chair in 1 minute.
Okay. I'm gonna come back to you, Mr. Dozy.
Thank you, sir.
Ms. Michon.
Good morning, Your Honor. Happy Monday. I have Mr. Sewell for PCC. I'm not sure who my prosecutor is on it.
It looks like I'm batting 1,000 this morning. I don't.
Our planets are not aligning, Judge.
Okay, I'm gonna come back to you as well. Mr. Alawamle.
Good morning, Judge. I'm standing in for Attorney Lemlin on Garwood, Garwood. We want to set it for an exam.
Let me call it.
Calling case number 23056280001, people of the state of Michigan versus Xavion Garwood. Defendant is charged in count 1, assault with intent to do great bodily harm, less than murder or by strangulation. Count 2, assault with intent to use weapon. Count 3, domestic violence.
Appearances for work, please.
Good morning, Your Honor. Shelley Drain for the people, P number 60249.
Respect to Your Honor, Attorney Alawamle, bar number 66874, standing in for the attorney record, Mr. Whitney Lemlin. On behalf of Mr. Garwood, Judge, we would like this matter to be set for an exam May 5th, if possible, Judge.
Are you waiving your client's appearance?
He's on Zoom, Judge. I saw him on Zoom.
Mr. Garwood, where are you?
Yes, right here.
Tell me your name for the record.
Xavier Garwood.
All right, court will continue to plea of not guilty and set it tonight for preliminary examination. You can't do April 24th?
No, Judge, the attorney has a conflict. He could do the 1st, the 2nd, the 4th, the 5th.
I have the 24th, the 26th, and the 28th available.
How about May 1st, Judge? Is that possible?
We have to go to May 1st. May 1st at 10 o'clock.
I'm sorry, Judge.
May 1st at 10 o'clock.
Thank you, Your Honor. Thank you, Judge.
Honor be continued.
Thank you.
Judge, I see Mr. Moore is in the chair. So if I could just have a breakout room, that'd be great.
All right, we're back on the record on people versus Moore.
Yeah, once again, Eric goes on behalf of Mr. Moore.
Okay. Go ahead, Mr. Dozy.
Yes, Judge, I just would like to have a breakout room so I can discuss the tethering violation report with him.
Thought you were ready. You said you just spoke to him.
I spoke to him on Friday, but I did not have the benefit of having a report in my possession at that time. Honestly, it'll take approximately 5 minutes. Thank you.
Going breakout room.
Thank you.
Mr. Garwood, you're all set. May 1st at 10 o'clock in person in 36th District Court. Mr. Brown. Looks like I lost Mr. Brown. Mr. Moxie.
Morning, Judge. Joshua, Germany. I just need to set an exam date and time.
Calling case number 2305-606601. People of the state of Michigan versus Joshua German. Defendant is charged in count 1, home invasion, first degree, count 2, domestic violence, count 3, larceny, less than $200. Defendant has a habitual offender, what against notice.
Appearances for the record, please.
Good morning, Your Honor. Shelley Drain for the people, P number 60249.
Morning, Your Honor. Andrew Moxie, P number 69568. I ask my client's presence be waived.
Or waive the defendant's presence. What's your pleasure?
Judge, I'm looking to set up an exam date. I was wondering if you had anything maybe this Monday, late morning, Monday, the 24th.
Sure do. How's April 24th at 11:15?
April 24th, 11:15. Got it.
I'll be continued. Thank you.
Thank you.
They accidentally brought his client down over here. He downstairs, but they're gonna send him back over. I just gave him to the court date.
Judge, I'm the APA on the Terrence Sewell case.
All right, okay.
Case number 2305-618701, people of the state of Michigan versus Terrence Sewell. Defendant is charged in count 1, torture, count 2, criminal sexual conduct, first degree, count 3, criminal sexual conduct, first degree, count 4, criminal sexual conduct, fourth degree, count 5, criminal sexual conduct, first degree, count 6, unlawful imprisonment, count 7, assault with intent to do bodily harm, that's the murder by strangulation, count 8, assault with a dangerous weapon, count 9, domestic violence. Defendant has a habitual offender or against notice.
Appearances for the record, please.
Good morning, Your Honor. Shelley Drain for the people, P number 60249.
Ms. Michon,
Yes, Judge.
your appearance for the record, please.
I apologize. Kim Michon, Neighborhood Defender Services, P 59167. It's my pleasure to represent Mr. Sewell. Judge, I have the paper discovery in the matter. I'm not sure if there is any digital. I would ask prosecution inquire.
I will do that.
Thank you. And we need a preliminary examination date.
Is this Mr. Sewell here? What's your name,
Yes.
sir?
Mr. Sewell, Terrence Sewell.
All right, the court will continue to plead not guilty and set this matter for preliminary examination. How's April 24th at 1:30?
That is a fine date, Judge.
All right, April 24th at 1:30, bond will be continued.
Judge, as to bond, would the court be kind enough to order a pretrial services review of the gentleman's bond? I know this court well enough to know you're not going to address bond today, given the nature of those charges. But on the 24th, you would be prepared if you had a DSU report.
You do know the court well, don't you? I will refer to pretrial services for bond recommendation.
Thank you so very much, Judge. Have a lovely day.
Thank you, you as well. Ms. Tussar,
Good morning. How are you?
good morning. Long time no see. What can I do for you today?
I'm just standing in for Matt Penny on the DeAndre Scott matter. I'm waiting for Mr. Crystal here. I think it was waiting to see if there was a independent competency report that came.
Oh, okay. All right, well, I haven't seen Mr. Kurtz yet.
I texted him. He hasn't responded yet. I'm going to try again.
Okay. Mr. Brown. Mr. Brown? Mr. Brown? Mr. Dozie, why are you back?
Oh, I just spoke with my client, so I'm ready to go.
Oh, okay. Mr. Brown. Mr. Brown,
Yes, Judge.
been calling you for the last 3 minutes.
Oh, I'm sorry. I was in a trial and I had to go into chambers with the judge. I apologize.
You here for Eli?
Yes.
Calling case number 2205-627901 for the state of Michigan versus Joseph Villa. Defendant is charged in count 1, assault with a dangerous weapon, count 2, malicious destruction of personal property less than $200, count 3, domestic violence. Defendant has a habitual offender, 30 days notice, and a commission of felony with the multiple advisory.
Appearances for the record, please.
Good morning, Your Honor. Shelley Drink for the people, P number 60249.
And good morning, Your Honor. Brian Brown, P 80560, appearing on behalf of Mr. Joseph Eli.
Are you waiving your client's appearance?
Yes, Your Honor. I believe he's still in the Wayne County Jail. I would waive his presence for today's hearing.
What's your pleasure?
First and foremost, we would like to request the discovery on this matter, and then we would like to set it for in-person preliminary examinations.
All right, the court will continue to plead not guilty. We'll set this matter for preliminary examination. How is April 24th at 11:30?
I start another trial on that day, which is next week. Can we do the 26th?
26th at 10 o'clock?
Yes, that'd be good.
All right. April 26th at 10 o'clock. Will be continued.
All right, thank you, Your Honor.
Mr. Brown, I will send you the paper discovery. There is no digital in this case, but I'll send you the paper today.
Okay, thank you very much.
Thank you.
I completely forgot I put you in a breakout room, Mr. Dozie, my bad. Are you ready on more now? Have to unmute yourself.
Yes, I am, and thank you. Yes, I'm ready.
Okay.
Calling case number 2305-633901, people of the state of Michigan versus Breon Moore. Defendant is charged in count 1, aggravated indecent exposure, sexually delinquent person notice, indecent exposure. Defendant has a habitual offender for defense notice.
Appearances for the record, please.
Once again, Eric Gozzi on behalf of Mr. Breon Moore, who is online somewhere. I don't see him on the screen. Is he still in the breakout room, Judge?
Oh, you know what? Might be. Yes.
Okay.
It takes 60 seconds to bring them out.
Well, it's not everybody's fault. I mean, it's snowing today, and it was 80 degrees on Friday. So I think it's just climate change has affected us all.
We live in Michigan. We can have all 4 seasons.
You're absolutely right. I think we've been going through climate change since I was a child. So yeah, this is true. Is up there.
There he is.
Thank you,
What's
Judge.
your name for the record, sir?
Mr. Moore, you have
Moore,
your name in the record.
Moore. All right, Mr. Dozie.
Thank you. Judge, I've had an opportunity to go through the report with Mr. Moore. We've discussed the terms that were laid out when he was assigned the tether. He does admit to the violation with an explanation, if I may.
Please.
Thank you. Mr. Moore is a caretaker of his great uncle, who I believe is in his 90s. who's diabetic and also is on insulin. Mr. Moore was checking in to make sure that he was doing this okay. He was also on his way to do CVS pharmacy to pick up his medication, his prescription for his various conditions. And that's when the deputies had found out that he was in violation. He did not put up any difficulties and freely was surrendered to their custody. We asked the court to take these into consideration and allow him to be placed back on the same original terms and conditions of his bond.
Mr. Moore, you didn't understand what house arrest meant?
Yes, sir. I apologize.
I don't get it. What did you think was going to happen?
Well, when I stepped outside, the tether didn't go off, and then I was dealing with my mental health, and I thought I was actually, and then I had court the next day, and I thought I was like, I was clear, but I see I was wrong, but I won't do it again. Give you another try. Yes.
What do you mean by? What do you mean by that?
I'm dealing with schizophrenic and depression. And when I left the jail, they gave me a 30-day supply of medication that I go to the CVS and have to get. Had to get.
Who do you live with?
I live with myself. I got Section 8 low-income housing.
That's correct, Judge. It's been verified. Community Housing Assistance has been working with him and has actually found him some housing, and it thus far. So we obviously would like to keep that so he doesn't lose his house if he gets incarcerated. Plus, he's also currently being treated at Team Wellness, and we would like, obviously, we will be more proactive in making sure that he is being monitored through them as well.
Who's your caseworker at Team Wellness?
Her name, Maisha. I got a therapist and a
Who's your therapist?
Her name Maisha.
He asked who your therapist is, Mr.
I think it started with a G. I actually can't pronounce his name. It started with a G though, Miss Gordonez or something like that. I think her last name is.
Is that Maisha or Aisha?
Maisha, like Maisha.
Maisha?
Yeah. They switched it up because I got a care coordinator too. So
Which location is that?
Russell, across from Eastern Market.
They don't have an Aisha there. I mean, a Maisha there. They have an Aisha.
Must be.
What's her last name?
I mean, sir, don't get me wrong. I don't know. I got like 3 people that I gotta see, man. I mean, they all knew actually.
Right, and I believe he's also being treated by Dr. John Head at Team Wellness in an outpatient basis.
Dr. Head is his doctor. Okay.
Yeah.
So what was this story about him taking care of his, what'd you say was his uncle?
Correct, Judge. He has a great uncle, I believe. His house. I did.
No, I thought that was the reason he violated, because he was taking care of his sick uncle with diabetes and was going to the pharmacy to get his prescription. Sounds like he wanted to Pharmacist to get his own prescription.
Then I misspoke. What I meant was to say he was checking on his uncle, and he was also on his way to get his own prescription from CVS for his own medication. Is that correct, Mr. Moore?
Yes, both. Uncle and me. That's what I was doing.
When is his exam date?
I believe we have it scheduled for the next week, Judge. I could just double check, but I want to say it's next Monday, 24th.
24th at 11.
Yes, sir.
That's today. No, it's next.
It's next week, Judge. And on that one, if I'm not mistaken, we have specially assigned prosecutor Elizabeth Moore, no relation, also on the case.
I take it you're not working anywhere, right?
Under the table or Selma on the Wyoming at a detailed hand car wash. I was trying to get my case manager to actually fax the teller lady everything, but she didn't fax that.
So, wondering, Mr. Gozi, how is he a caretaker? And he sounds like he needs a caretaker himself.
I totally understand that, Judge, but you know how people can be living on the margins of society, and they have to do what they can to take care of for any family members. No one else is willing to step up. Obviously, they're employed, and Mr. Moore is the only one extensive free time, despite the fact that he works at a car wash. Gives him more flexibility to look over it his own. Honestly, Judge, I don't think that this is one of those situations where he's making excuses just to try to continue violating. I think that he's being genuine, given his concerns, and I'm kind of impressed that he's able to carry himself such that he is, notwithstanding his mental health malady.
Well, the tether and house arrest was a gift.
I understand.
Kind of threw the gift in my face.
I don't believe that was an intention, Judge. I think it's more misunderstanding on his part.
Now, what I think happened is when he stepped outside and the tether didn't go off, he got an inch and took a mile. He figured that it's not going to go off. It's not working. So he took that as an opportunity to do whatever it is he wanted to do. I do appreciate that the defendant appears to be honest and forthright with me, though. They have it now to where medication and groceries and the like can be delivered. That's what he's going to have to do.
Okay.
I'll reinstate the house arrest.
Thank you, sir.
Sir, one more slip up in this over with, done. I'm not letting you back out, understood?
Yes, sir.
So when I say house arrest, that's exactly what it means. Your house is your jail. Got it?
Yes, sir.
You can't abide by that, let me know now. We can cut to the chase and you can stay right where you are.
Oh, so I will apply. I will adapt to it. I'll adapt to it, sir. I'll adapt to it. All due respect.
I'm giving you another opportunity because you're honest. All right, so we'll reinstate the house arrest. Thank you, Mr. President.
We appreciate your grace, Judge. We'll see you next.
Mr. Chris.
Good morning, Judge.
You are here on Andre Scott.
Andre Scott and Jayon Williams. Jayon Williams, I said.
Yeah, okay.
Call on record.
Yes.
Calling case number 2205-9911 before the state of Michigan versus defendant number one, Andre Scott Jr. is charged in count one, assault with intent to murder, count two, controlled substance, delivery, manufacture, cocaine, heroin, or another narcotic less than 50 grams. Count three, weapons, felony firearm. Count four, weapons, felony firearm.
Chances for the record, please.
Good morning, Your Honor. Erica Tusar standing in for the attorney of record, Matt Penny, on behalf of the people, P56831.
Hey, good morning, Your Honor. David Cripps, P34972, appearing on behalf of Andre Scott Jr., who's currently in the Wayne County Jail.
Mr. Scott, tell me your name for the record.
Andre Scott.
All right, today's date and time set for a competency hearing.
Yes, Your Honor, there are two reports regarding competency. They both recommend that Mr. Scott is competent to stand trial.
Okay. That being said, are you willing to stipulate to those findings?
Yes.
Court makes it you as well, Ms. Tusar?
Yes, Your Honor. I wasn't aware there are two reports. We have one from the Forensic Center. I'm not aware of the other one.
I thought the other one was the independent.
The other one is the independent. I thought I forwarded to Mr. Penny and the court
Okay.
last week.
Could you just send me another copy when you get a chance, and I'll make sure Mr. Penny gets that?
Yes.
Thank
All right,
you.
the court makes a finding that the defendant is competent to stand trial. What's your pleasure, Mr. Cripps?
Preliminary examination to be set, please.
I believe there's one set for the 21st, according to Mr. Penny. I don't know.
21st of what?
April.
April 21st.
I had my book for April 21st at 11 o'clock.
Okay, that sounds about right. It's probably 11:30.
11:30, I'll change that. It's fine.
Thank you.
April 21st, that's a Friday. Yep, okay, April 21st at 11. It is 11 o'clock, I'm sorry. Is that what you have?
Yes.
Yeah, it's 11 o'clock, April 21st. File will be continued. Thank you.
Thank you, Your Honor.
Next up is Dan Williams.
He's on his way up.
You're all set, Mr. Scott. Mr. Green, are we ready on Williams?
Excuse me, Judge King.
Yes, sir.
So that's all I have for you today.
All right, thank you very much. Have a great day now.
You too. You and your staff have a good one.
Three. Not in county jail,
Right, he is saying this wasn't breathing,
straight here,
but you know, they process the wake up.
he's not in there, so they didn't get to the county jail.
Who is that?
Santiago, no,
Johnson.
Johnson, Joshua Johnson. 15.
I think Ms. Drain is probably on her way over.
Oh. I thought we waited to defend it.
Judge, I am on my way over. However, I would inquire as to whether anyone has checked in yet, a complainant. I don't think so, but
Do we have any witnesses here on Jayon Williams? All right. We can go ahead. Call that. Are you expecting anyone, Ms. Drain?
no, Judge.
Gonna go through this small door right here.
Calling case number 2206-015001, people of the state of Michigan versus Jayon Williams. Defendant is charged in count 1, home invasion, first degree. Count 2, assault with a dangerous weapon. Count 3, assault with a dangerous weapon. Count 4, child abuse, fourth degree. Defendant has a habitual offender or defense notice.
Appearances for the record, please.
Good morning, Your Honor. Shelley Drain for the people, P number 60249.
And good morning, Judge David Krebs, P 34972, appearing on behalf of Jayon Williams, who's here in court.
All right. There's a date time set for preliminary examination. Everybody's proceed.
Your Honor, I am not prepared to proceed to the exam today. The complaining witness was notified of today's date and time. They are not present. I cannot proceed without testimony today.
The defense would make a motion to dismiss without prejudice.
So ordered. The court will dismiss this matter without prejudice.
Thank you, Judge.
Have anybody here on our 915 Shaquille Miller?
Yes, Your Honor.
Yes.
I think, I have another exam here at 10:15.
Okay. At least I know where you are. Right? Right this way, sir. Okay. I'll let you get settled in, Mr. Attorney. Ms. String?
Yes, Judge.
Shaquille Miller. Calling case 2355737 for the state of Michigan versus Shaquille Miller. Defendant is charged in count 1 home invasion, first degree, count 2 assault with a dangerous weapon, count 3 domestic violence.
Good morning, Your Honor. Shelley Jones of the People, P number 60249.
Good morning, Your Honor. Neighborhood Defender Service by Cheryl Quick, P 83973. On behalf of Shaquille Miller, Mr. Miller is present just behind me to my left.
Tell me your name, sir. Shaquille Miller. There's date, time set for preliminary examination. Are you ready to proceed?
Your Honor, I am not able to proceed at this time. The complaining witness is a Ms. Lakeela Jefferson. She is not present. I cannot proceed without her testimony.
Your Honor, it is just after 9:30. This was set at 9:15. Ms. Jefferson not being here, we move to dismiss.
So ordered, the court will dismiss this matter without prejudice.
Thank you, Your Honor.
The parties on Santiago Maldonado.
Good morning.
En la silla de. Ephraim Santiago Maldonado. Calling case 2356218, people of State of Michigan versus Ephraim Santiago Maldonado. Defendant is charged in count 1 assault with intent to do great bodily harm, less than murder or by strangulation. Count 2 assault with a dangerous weapon. Count 3 domestic violence. Appearances for the record, please.
Good morning, Your Honor. Shelley Jones of the People, P number 60249.
Good morning, Your Honor. Catherine O'Hara, P 53823 on behalf of Mr. Santiago Maldonado.
Your name for the record, sir?
Good morning, Your Honor. My name is Jose Ruiz. That's Jose. Last name Ruiz as in zebra. And my Q number from the state of Michigan is Q4330, Your Honor. I am a Spanish-English interpreter.
All right, please raise your right hand, sir.
Yes, sir.
Do you swear or affirm to translate from English to Spanish and Spanish to English to the best of your ability?
Yes, Your Honor.
Thank you, sir.
Thank
Your
you,
name
Your
for the
Honor.
record, sir?
Su nombre para el récord, por favor.
Santiago Maldonado.
Okay, today's the date and time set for preliminary examination. Are you ready to proceed?
Esta es la situación que es para el día.
Your Honor, I am
Estamos
not able
ahí.
to proceed at this
No
time.
puedo proceder en este momento.
The complaining witness is a
el
Ms.
testigo
Liliana Fuentes.
es
She is
Liana
not
Fuentes.
present, and I
No
cannot
está
proceed
presente
without
y
her
no
testimony.
puedo proceder sin su
We're asking
testimonio.
for dismissal.
Estamos pidiendo que se
So
limite
ordered, the court will dismiss this matter
a
without prejudice.
Entonces, declaro que vamos.
Your Honor, if I could just place on the record, I don't know what's going on with the jail, and I don't know how to bring this to the court's attention or the jail's attention, but they charged Mr. Santiago Maldonado $200 for his GPS tether that was part of his bond, and told him that he would have to keep paying $100 a month for that tether, and I just watched the presentation that we were required to watch about the bond partnership thing, and it was my understanding that there was no charge for the tethers that was required to bond. So I have a call into Chief Ramble, but I don't know what's going on with that, and I just wanted to put that on the record. He paid the $200 because he wants to do what he was asked to do, and supposed to do some orientation they gave him, but,
It's not going to be learned until now.
right, I understand, he already paid the $200, and if this is something that's happening to other people, I'd like it to be addressed, because I thought that was not, that was something that was specifically prohibited, was requiring people to keep paying money to maintain the freedom.
Pidiendo $100 para que nos devuelvan su
Well, anyway, there
situación.
it is.
Eso es lo que quisiera decir.
And I'll keep pressing it through the channel, I don't understand why that is.
Enseñando esta situación.
I'll bring up the.
Ella va a venir va a venir con las órdenes. I'm sorry, that approach. Yes, I do appreciate it. Your Honor. Yes, you don't need me anymore for any other cases, sir.
Have anything else to sign?
No, sir, I do not.
We all set.
That's working with you, sir.
All right, thank you, sir. Appreciate you.
Thank you. Thank you. Thank you, sir. You too, sir. By the way, did they ask you today to have a mask? No. Okay. You can, if you want. Okay, thank you, sir.
Nice meeting you.
Morning, everyone.
Vice Chair. Vice Chair.
Morning.
Christopher Minion. Yes. Calling case 2356208, what state of Michigan versus Christopher Earl Minion. Defendant is charged in count 1 assault with intent to do great bodily harm less than murder or by strangulation. Count 2 domestic violence. Defendant has an additional offender force offense notice. Appearances for the record.
Good morning, Your Honor, Shelley Baker, people, P number 60249.
And good morning, may it please the report, Sophia Curry, T72103, appearing on behalf of Christopher Minion.
Number again.
Sure. 72103. Mr. Minion, please state your name for the record.
Christopher Earl Minion.
Today's the date, time set, preliminary examination, everybody please proceed.
Your Honor, I am not able to proceed at this time. The complaining witness is a Ms. Elizabeth Ford. She was notified of today's hearing, and she is not present, Your Honor. I cannot proceed without her testimony.
The defendant make a motion to proceed, Sharon.
So, or the court will dismiss this matter without prejudice.
Thank you.
Okay, I think.
Amazon's AI sales has completely commenced.
Trias Plummer.
Yeah,
Can I help you, sir?
do I supposed to be in court today?
You're not on my docket. What are you
Okay.
charged with?
Like DB, they told me I got out Saturday, and they told me to go on Zoom today to contact somebody about my court date.
What are you charged with, sir?
Domestic violence.
Trias. YS. Torrance, PM.
Yeah, so he has a pre-trial before 20 before Judge Austin.
Okay, you have a pre-trial before Judge Austin Garrett
420.
on April 20th.
Okay, April 20th. What courtroom would that be? What's the court number?
338. So it's going to be 360 338
360 338
0000.
0000. Oh, so I call this number right here and they'll tell me what to do?
Just like you appeared today, you have to appear there on April 20th.
Okay, on April 20th. April 20th. Okay, thank you.
All right.
Okay.
Good morning. How you doing? They can come on in, you can get started.
All right. We'll let Ms. Drain know she's up.
Okay, thanks.
Wanna go against the
PPO. Right. But okay, so just go if you have to go and get your if you gotta go and
Mr. Babs?
good morning, Judge. How you doing?
Good, how are you? What can I do for you?
I'm pretty good, thank you. I'm actually trying to zoom on for our exam that we have scheduled for 12:30 today to address discovery issues. We were just in the court on Friday, but I actually just spoke with Ms. Drain also regarding this.
What kind of discovery issues?
I still don't have the discovery that's necessary for the exam. We do have a discovery order, but the 911 calls, Ms. Drain, I was hoping she would have it to me over the weekend. And I just spoke with her. We still don't have them. The exam is scheduled today for 12:30.
Do we know that 911 calls exist?
Oh yes. That's the initiation of the case. And I can let Ms. Drain go further into it, but she was more so seemed like she was waiting on the 911 calls, to my understanding. But I don't want to make any representations on her behalf, just in case she misspoke to me. I don't know. Is she in the courtroom, Judge?
I think she stepped into the hallway.
Okay, my client can Zoom on, but I'm actually, do you, would you prefer for me to actually come into the courtroom rather than zooming on?
Doesn't matter, either one.
I'm sorry, Judge, I didn't hear you.
This case is scheduled for exam at 12:30, so you should probably be here.
I think you're muted, Judge. I see you moving your lips, but I can't hear you.
I said you're scheduled to be here at 12:30 for exam, so you should probably be here.
Oh yeah, so here, my client, he would be more so zooming on, but I can no, he was there at 8:30, but they told him 12:30, so he left.
Our officer just said he's in the hallway.
No, I'm on the phone. I'm on the phone.
Sorry.
She said he left, so he probably left.
Yeah, he left. Yeah, he thought it was at 8:30, but so he came at 8:30.
Well, both of you are due here at 12:30.
Right, I know, Judge. It's only 10 right now, so I'm down here for a different case. But he was down there, and then they told him it was 4 hours away. So he left and was going to come back. But if you need for him to come down sooner, then I can ask him to come down. It's just that I hope that we could actually.
I'm expecting you guys at 12:30.
Right? Should we, Judge? I would ask the court to address the discovery issue, because if it's going to be a dismissal or an adjournment or anything, I would ask for the court to address it.
Also a possibility that it may go.
I'm sorry, Judge.
There's also a possibility that it may go.
And is that what I would be asking for, a dismissal, Judge, or an adjournment, because those 911 calls would be critical for the exam. And there actually is a discovery order that was signed by the court.
That sounds like something we'll be discussing at 12:30 when you're here.
I understand, Judge. In the past, you've also asked me to come on sooner to address discovery issues, so we didn't wait till the exam, because if it's going to be a dismissal, then we could address it much sooner.
Sooner, I don't mean sooner as in the day of. I mean sooner as in days before. So something can be done. We can have the exam go on the day that it's set for, not on the day of the exam.
Right, I understand. We were just on the we were on the record on Friday for this case, but it was regarding other discovery stuff, obviously, Judge. But I guess I'm just, if it's going to be an adjournment or a dismissal, may I contact attorney Ms. Shelley Drain to see if those 911 calls do exist? Because if we could, if the court would entertain a due process violation and actually dismiss the case, then I would ask for us to do it before 12:30.
You probably need to be here at 12:30 to make your argument for the dismissal. That's what you're going to do. Or an adjournment, that's what you're going to do. Or if we're going to hold the exam, I need you here anyway.
All right, Judge.
Yolanda Henry. Oh.
I have to check in on an exam upstairs. Checking while we're waiting for the stream.
Where is she? She's not at home.
She's talking with her appointed interviewer.
Mr. Grant, Mr. Bass contact report again on nerve about some 911 calls.
So I saw she sent me an email and asked for a discovery and specifically the 911 calls. So I then sent an email out requesting, I was trying to give the exact date, but requesting that I believe it was last Thursday, requesting the 911 call. And I told her I requested it and I have been checking and I still do not have that 911 call, and I got her to know that yesterday, that I still don't have it. So I don't know that she is, I don't think that she is willing to go forward with the exam without that 911 call. I saw her this morning, actually, at Frankfurt, she said she would probably Zoom in before the exam today. So we could just
What is your officer in charge saying about that?
Well, Your Honor, I sent a request from our office to the unit that actually we can get 911 calls from, and that we frequently do. And I have gotten no response yet. That's the issue. I personally requested that from the unit that gets the 911 calls for us. Because so we are trying now to request 911 calls right when a warrant is signed so that we have it, but we didn't have them for this one. So I made a request still for that, and I have not gotten it yet.
So who can I show calls? Is there a blind person you talk to when you make this request?
No, it's a specific unit, and it's you send an email and I will. So it was Thursday? Yes, it was Thursday, and it is, oh, well, the email is, it's an IHIK at DetroitMRI.gov. So I think that was actually.
Okay, so what was that? Winfield, I'm sorry. Calling case 2356154, people of the state of Michigan versus Danielle Monique Winfield. Defendant is charged in count 1 assault with a dangerous weapon, count 2 unlawful driving away motor vehicle, count 3 felony firearm, count 4 domestic violence. Appearances for the record.
Good morning, Your Honor. Shelley Ring for the people, P number 60249.
Hey, good morning, Judge David Cripps, P 34972, appearing on behalf of Danielle Monique Winfield, who joined us.
Tell me your name for the record, ma'am.
Danielle Monique Winfield.
Date time set for preliminary examination. Are we ready to proceed?
Yes, Judge.
Judge, there is an issue as to discovery. I believe at the probable cause conference of Ms. Kraus was covering that. And there was a request made for all digital discovery in this case. We have received paper discovery, but we have not received digital.
So why is it that we waited to the day of the exam to address the discovery issue?
Your Honor, if I may, Ms. Kraus did contact me and indicated that yes, she does have paper and was requesting digital evidence for this case. And so I knew that she wanted that. And so I then sent an email to the officer in charge on Friday, evening, indicating that we had exam on Monday and I'm requesting any all digital discovery for this case. And then Sunday, yesterday at 4:54, I did receive an email from the officer in charge of this case indicating the video had been uploaded to evidence.com. I looked under every single, under the case number, under the police report number. I was not able to find it anywhere on evidence.com. I emailed him back saying, I don't see it. Is it under this number? And he said, yes, it is. And that was very, very late last night. And then I did email. Yes. Yeah, at 8:29, I did email Ms. Kraus back, and I did indicate to her that the officer in charge said that he had uploaded it, but I mean, I do discovery all the time, and so I know where it went, and it's not on. And so this was late last night. So I don't know, I don't know what to do.
Is defense concerned that that digital discovery may contain body cam video of the interview with the complainant, among other things? So defense at this time would make a motion to dismiss without prejudice, allowing prosecution plenty of time to reissue and find the evidence that we think is crucial for this exam.
Why would I dismiss it at this stage?
Because we don't have discovery, plea discovery in order to conduct the cross-examination.
Would you do a motion to compel or discovery order?
Well, you heard the sequence of things. It was,
I didn't hear anything about a motion to compel discovery or discovery order. I think.
Well, I don't know what more we can do, honestly. We come to probable cause conferences, we make a special request.
You make a special request, you don't receive it, and you bring it to the court's attention. And then you have much firmer ground to stand on and asking for a dismissal. Isn't that the way things would proceed in federal court? You made a motion to compel or
Motion to
release a
compel.
discovery order,
Yes.
so it shouldn't be any different there. So that request would be denied.
I might advise my client of further options. She wishes to go have the exam.
Okay.
As opposed to German. Is that correct, ma'am?
Yes.
All right, let's do it. You ready to call your witness?
Yes, Your Honor. I have two witnesses that I would be calling. The first witness would be Jason Kenneth Johnson.
Motion to sequester, Your Honor.
Ladies and gentlemen, out there in YouTube land, if you are a witness or potential witness, I order you to log off at this time. There appears to be no other witnesses in the court. I'm not sure who that is. In fact, it kind of looks like Ms. Shabazz, but I'm not sure. Is that you, Ms. Shabazz?
Yes, Judge.
Okay. Ms. Shabazz must have something else going on that she's scheduled at 12:30 because she's trying to press me to handle her thing now. Did you double book, Ms. Shabazz?
No, Judge, I'm a little hour away, so I'm
Oh,
here.
okay.
I ain't got nowhere else to go.
All right. You can call your witness.
Who would call Jason Kenneth Johnson?
Please give your name and spelling to the young lady seated there. Please raise your right hand, sir. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you, sir. Please have a seat in the witness box right next to me. Voice up nice and loud and speak into that microphone. It's going to be to your left. Okay, let's pull that out. Maybe getting ready.
Speaking to the microphone.
Go ahead.
Thank you. All right, please state your name once again for the record.
Jason Johnson.
All right, Mr. Johnson, I'm going to be asking you some questions today. If you don't understand something or if you want me to repeat it, please let me know, all right? You always have just have to answer with a verbal.
Oh, okay, yes, ma'am.
Okay, thank you. All right, Mr. Johnson, I want to bring your attention back to the date of June 25th of last year, 2022. Do you remember that date?
Yes.
What were you doing on that date?
Actually, I was door dashing that day before I went over there to the defendant's house.
Okay, that was your job, door dashing. Okay, and you said,
Yes,
all right, you said you were doing that before you went over to the defendant's house,
yes.
and who is the defendant?
Danielle Whitfield.
All right, and how do you know Danielle Whitfield?
We was in a relationship for about 2.5 years.
Did you have any children together?
We possibly have a son together, yes.
Okay, and do you see Mrs. Danielle Whitfield in the courtroom here today?
Yes.
For identification purposes, could you indicate where she is and what she's wearing today?
She's sitting to my right and she's wearing a brown little blouse.
Okay.
Blouse type.
All right, thank you. Your Honor, please let this record reflect that this witness has identified the defendant, Ms. Danielle Whitfield.
So noted.
Thank you. All right, you indicated that you went to her home, is that correct?
Yes.
And where is her home located?
Her old residence is located off of MLK and 14th Street.
Okay, so, and I'm talking about like the incident that happened on that day, is that?
Everything happened in the bedroom.
Oh, and what's the address?
It was 3094 14th Street.
Okay, and is that an apartment or unit?
Yes, it was an apartment.
Oh, do you remember what number?
4.
Could it have been a different number? Okay.
Yeah, that's our allowed, sir.
No.
Okay.
No, that's the only number.
Okay, thank you. So do you know approximately what time you got there?
It had been a little bit before midnight.
Okay, and what happened when you got there?
I went there. I was like I stated, already tired. So I went there. I went into her bedroom, and I had laid down on the bed because me and her was watching TV.
Okay, so you come in the house and you go to the bedroom and you go to sleep, or what happened?
No, I didn't go to sleep right off rip because we was watching TV before I went to sleep.
Okay.
So after a few minutes of us watching TV, I fell asleep.
Okay. Were both of you in the bedroom at that time?
Yes.
Okay. So what was was everything fine between the two of you during that time before you fell asleep?
From what I thought, yes.
Okay. Did you have any arguments, anything like that before you fell asleep?
No, actually everything was cordial.
Okay. And both of you were in her bedroom?
Yes.
Okay. So you go to sleep. What happens next?
I go to sleep and I wake up to her hitting me in my face.
Okay. Now, was anyone else in the house that you know of?
No, it was just me and her.
Okay. And where was the child that you had?
He was actually at my mother's house.
Okay, so that's a different location.
Yes.
Okay. All right. So you wake up to her punching you in the face?
Yes.
Okay. And what did you do?
I had tried to defend myself, but she pinned herself up on top of me like an MMA fighter. So basically I couldn't break free. Every movement that I made from the bed onto the floor, she followed my every move.
All right. And what was she hitting you with?
Her face.
Okay. How many times did she hit you?
I honestly really can't answer that. because it was repetitive
Okay,
over and over and over again. So I really can't even put it on today.
okay. And was she hitting you just in your face?
Yes.
Okay. And how long did this go on for, do you remember?
I want to say like, if I put a time on it, probably like 15, 20 minutes max.
Okay. Was she saying anything to you while she was hitting you in the face?
She had my phone in her possession the whole time, taking pictures.
She was taking pictures with your phone?
Yes.
Okay. And, okay, so did she say anything to you?
She was basically just talking stuff over there like that as she was hitting me, but as she was hitting me, she took pictures of it. And then not only taking pictures of it, people were calling my phone because she imposed herself like she was me.
Objection, Your Honor. Speculation, Mark, as to why people were calling it.
Sustained.
All right. Did you, so you said she was taking pictures of you?
Yes.
Okay, so, did you see the pictures on your phone that she took of you?
I didn't see the pictures until I finally had to get a hold of the phone because after when everything happened, she still had my phone and she went to Toledo with my phone. And how I found out, I had used one of my friend's phones to sign in into the find my iPhone app, and that's when I found out she was in Toledo with my phone.
Objection, Your Honor, pure speculation.
Well, Your Honor, I don't think it's speculation. He's saying he was able to determine where his phone was, and he said she took his phone. Maybe he couldn't determine she was in Toledo, but she said
Okay,
the.
you have opportunity to process.
All right, so did you ever see the pictures on your phone?
When I had to get a whole new phone and I signed into my new phone, yes, I seen it.
Okay, and what did those pictures?
Objection, Your Honor. Again, I'm limited by the fact that I haven't received digital evidence, so I'm objecting to her going in.
Violates the best evidence rule as well. Sustained.
I'm sorry, I'm just texting you. Evidence, so I'm checking.
Yes, that's what I said.
All right, did you look in the mirror that day at all?
I didn't want to, but of course I did.
Okay. And what did you observe about yourself when you looked in the mirror on that day?
The thing I was asking myself is, how did I land myself into this type of situation? Because it's my first time ever going through something like this. Like I ain't never had a problem with anything because I'm not a problematic type person. So I don't ever put myself in these type of predicaments.
Okay. What I want to know is what did you observe about yourself physically when you looked in the mirror after this incident?
Well, when I had left the hospital and stuff.
But did you look in the mirror before you went to the hospital?
No, I didn't.
Okay. All right, so you, after this incident, you went to the hospital?
Yeah.
Okay, and was it the same day or a different day?
No, same day.
Okay, and why did you go to the hospital?
I went to the hospital because my eye was hurting bad.
Your what?
My eye.
Oh, okay.
Let's see, so they did a CT scan. I had a broken blood vessel in my left eye.
Objection, Your Honor. Hearsay.
Objection,
hearsay.
Your Honor, may I ask a further question?
Okay, I'll take the objection on your side.
Oh, You're saying, you said you had a broken blood vessel in your eye. Could you observe that in your eye? Or was it just that they told you?
Well, describe your eye to us. Was it injured?
Oh, yes, most definitely it was injured.
How could you tell your eye was injured besides it hurt?
It was black and purple all around, like my eye was almost shut.
Was there anything inside your eye that you could see, like, could you see like your pupils and the whites of your eye clearly?
The only thing that I could see was like a little bit of space that I could see through my eyes when I had looked through the mirror after I left the hospital. My whole eye was red.
Okay.
It wasn't no whiteness in my eyes like how you see it now. My whole eyes were red.
Okay. All right, so you had a CT scan. Was there any other test or treatment that you received?
They said that I had a
Objection, hearsay, Judge.
They said that I had a broken.
Objection.
Hold on, sir, there's an objection. Stop.
What, other than what they said, what other treatment, if any, did you receive?
The only treatment that I received was them giving me antibiotics. That was it.
Okay. And was it just treatment on your face or anywhere else that you received treatment?
No, just on my face.
Okay. And you said it was just, you went to the hospital one day and you left the same day, is that correct?
Yeah.
Okay, so let's back up a little bit. So, you said that this went on for like 15 minutes of the defendant
If I
punching.
was to put a time limit on it, yes.
Okay, so what happened after that? How did it stop?
After the beating had stopped, she took my car and she went over there to my mom's house where the baby was.
Okay.
Objection, Your Honor, no foundation.
Sustained.
Okay. I'm gonna back up a little bit. So you wake up, she's beating you in the face. Okay, and then how did that stop?
Well, she threatened me because it was a rifle in the corner behind her there.
Whose rifle is it, if you know?
It was hers.
Okay, have you seen it before?
Yes, I have seen.
Okay, so you said it was behind the door?
Yes.
Okay, so you said she threatened you with it?
Yes, she did. She kept pointing to me. And as she was pointing to me, she was talking her stuff as well.
No, let me stop you for a minute. You said she was pointing to you. What
No,
do you mean?
she was pointing to the rifle.
Okay. And then,
She was like, you don't know what I can do with this and all that, stuff like that. But she was like, well, I'm not gonna kill you because you broke anyway. And then that's when she left. She left and took my car.
okay,
And went over there to my mom's house.
okay. So,
Objection again about leaving the car for foundation.
Where she went.
pardon?
Not that she left the car, but where she went.
Well, I don't think you testified here or saw that, Judge. Speculation.
Okay, let's put that up. Did you see her take your car?
She took my keys. I physically seen her take my keys.
Okay, she took your keys. Was your car out there?
Yes, my car was out there.
Okay, after she took your
But
keys.
when I looked outside after she left, because I waited a couple minutes to see if she was gonna come back. When I looked out there, my car wasn't out there.
Okay, so your car was gone, she was gone, and your keys were
Yes, as well as my phone.
So as to the rifle, she just pointed at it. Is that
Yes.
correct? Okay. And, well, how did you feel after she pointed after the rifle and made the statement to you?
I mean, at that point, whatever that was gonna happen at that point.
Okay.
That's
so
really how I felt.
Were you,
The fact that I was attacked in that matter, I felt defenseless.
you felt defenseless?
because of how I was attacked.
Okay. How far away was the rifle from where she was?
Could have been no more than like 15, 20 feet.
15, 20 feet?
Yeah.
Okay. All right. And so she didn't take the rifle? Is that
She
correct?
took the rifle with her when she left.
Okay. And after she left, you said you saw her take the keys and then your car was gone.
Yes.
What did you do after that?
Well, I tried to go to several gas stations so I can try to call my mom, call my dad to let them know what was going on, but nobody would let me take one.
Okay, so you were walking to different gas stations?
Yes.
Okay. So what happened after that?
So I could have went to the hospital, but I chose to walk over to my friend's house because I didn't know if she was going to go over there and do something to her.
Okay, so you went to your friend's house?
Yes.
What happened after that?
After I went to my friend's house, my friend wasn't home, but she always had told me that I was more than welcome to go through the back door and stuff like that, to wait on her if she wasn't home. She didn't, she came back probably like an hour or two after I had went back there. So when my friend seen my face, she really couldn't believe
Objection
it
as to
because
what
from the
somebody,
pictures.
I have to object to what somebody else saw you.
Sustained.
Okay, so you're at your friend's house and
Yes.
your friend comes home.
Yes.
So what happened after that? You stay there, you go anywhere, what happened?
No, I stayed there.
Okay. And what happened, how long did you stay there for?
I stayed there up until the police came.
Okay, so did you call the police?
Yes.
And how were you able to call the police?
I had called the police through her phone.
Okay. And did the police arrive at that location?
Yes.
And did you make a report then?
Yes.
Okay. What happened after that, if anything?
After that, then, that's when I went to the hospital.
Okay. And did you have any contact with your father that day?
Yes, because he was there, he was there while I was in work as well.
He was where?
He was at my friend's house here.
Okay. And when was it that your father arrived?
My father arrived, I want to say like 9:30, 10 o'clock that morning.
Okay. At your friend's house?
Yeah.
Okay. And we're gonna push the witness.
Yeah.
I'm handing you that document. Do you recognize that document?
Yes.
What is that?
That's, I was just trying to, I had sent the prosecutors, a few pictures of the aftermath after I left the hospital.
Okay. So what does that picture show right there?
My injured eye.
Okay. And did you take that picture?
Yes, I did.
Okay, was that on the same day that it happened or within the same time period? You said after you went to the hospital, is that right?
Right, exactly.
Okay, all right. And you said but you don't have the pictures from your phone?
No, actually, but, my father does. My father still has those pictures from that very night it happened.
Your father has those pictures.
Yes,
And what's your father's name?
Jay Johnson.
Pardon?
Jay Johnson.
Jay Johnson. Okay. And did you give him the pictures from that night?
Yes.
You did. Okay. All right. Okay, I have no further questions at this time.
Cross exam.
Thank you, Honor. Good morning, sir.
Good morning.
Can you give me your complete name, please?
Jason Kenneth Johnson.
And within the last 10 years, have you been convicted of a felony or a misdemeanor involving theft, dishonesty, or false statement?
I've been charged with a couple of misdemeanors within the last 10 years, but no felonies.
What have you been convicted of in the last 10 years?
Hold on, sir. Does it involve theft, dishonesty, or false statement?
No.
No retail fraud, no stealing.
No.
You testified that my client, Miss Winfield, was living at a different location from you at the time of this incident. Is that correct?
Yes.
So you went over to where she lived. Is that correct?
Yes, because she wanted me to come over.
You went over to her residence.
Yes.
And how do you know that she wanted you to come over?
Because she had gave me a call that night and had wanted me to come over.
Okay. And so you made a decision to come over then, is that right?
Yes.
Okay. And prior to arriving there, were you drinking any alcohol?
No.
Smoking any marijuana?
No.
Using any narcotics of any sort?
No.
Have a weapon with you?
No.
And you arrived and how did you get in the house?
I simply walked in the door. She always leaves her door unlocked, so I just simply walked in the door. I walked up the steps leading to her apartment, and I walked in.
It's around midnight, is that right?
Yes.
So you walked in the front door.
Yep.
You didn't notify her you were coming prior to that arrival, is that right? Other than the phone call you said you had earlier.
Well, when I was on my way, of course I had let her know. I just didn't barge myself in.
So
She already knew I was coming.
So by the phone call?
Yes.
And on your own phone?
Yes.
Okay. And so then you came into her apartment, is that
Yeah.
right? And then she was in her bed, is that right?
Yes.
And you got into bed with her?
Yes.
And you said that you fell asleep?
Yeah.
Did you drink any alcohol at that location?
No. Even though I did buy a bottle of wine, but that bottle of wine was never open.
So you brought a bottle of wine with you?
Yes.
Did you smoke any marijuana at that location?
No.
So you just fell asleep, is that right?
Yes, after a few minutes of us watching TV. Yep.
No arguments, no nothing, you just fell asleep?
Yep.
And then you woke up, is that correct?
Yep. Yes.
In bed?
Yeah.
With her hitting you?
Yes.
What did you say?
Well, I really couldn't say anything because my mind was in defense mode.
All right, so because your mind was in defense mode, what did you do?
I really tried to defend myself to free myself.
Oh, I understand that. I asked you what specifically you did.
I tried to defend myself.
And what did you do?
Try to block her punches.
Did you throw punches at her in return?
No, I didn't, because I couldn't get myself free. She pinned herself on top of me like an MMA fighter.
Okay.
So ask yourself, if you had a woman her size on top of you, could you get free?
Well, she was your girlfriend, is that right?
Yes.
Okay. And so you were well aware of everything about her prior to that night?
Well, I didn't know that I was going to get beat on like that night.
All right, so this beating's going on and you're defending yourself, and you're going back and forth, right?
Well, it wasn't no going back and forth if you will see the pictures.
I'm not asking about the pictures, I'm asking about your memory of.
I was defending myself
It's a simple question. What were you doing to defend yourself? That's all I'm asking.
I was blocking her punches.
So you're blocking her punches, right?
Yep.
And then eventually, after a few minutes go by that you described, and then you got up, is that right?
Yes.
Did you have your clothes on at that time?
Yes.
So you were fully clothed while you were in the bed?
Yes.
Okay. And so then you left, is that right?
Yes.
Okay. And she had left prior to you leaving, is that right?
Excuse me?
She left before you left?
Yes.
And then you said you walked to a couple gas stations, is that right?
Yes.
Eventually you came into contact with the police
Yes.
and you refused to go to EMS, is that right?
At first I did, but like I just stated, like, I could have went to the hospital, but I was more so concerned about.
Thanks for all that. All I was asking is, did you refuse EMS?
No, when they had offered me to go to the hospital, I went to the hospital.
I have a police report here that says that you refused EMS. Would that refresh your memory?
Well, if I were to refuse the EMS trip, then why would I even go to the hospital to begin with?
We'll let the judge decide that. All I'm asking is, I have a report that says you refused to use EMS.
I'm gonna object. We don't have a report that's entered here. And.
Sustained that would be consent.
I'm trying to refresh his memory.
You're testifying that there's a report.
Yes,
That's not how you impeach the witness.
I understand. I want to lay a foundation in case I want to.
We're laying a foundation, but right now I'm going to sustain that objection.
Well, eventually you said you went to your friend's house.
Correct.
What's your friend's name?
Brittany Hardy.
I'm sorry, I couldn't hear you.
Brittany Hardy.
Brittany Harvey?
Brittany.
Brittany. How do you spell that?
Britnae. Hardy, Hardy.
And the reason I'm asking that is you said you used Miss Hardy's phone, is that right?
Yes.
No further questions.
Can you redirect?
Your Honor, I have no redirect for this witness. I have no further questions at this time. I would, however, reserve the right to call this witness.
Sir, you say that after the Ms. Winfield assaulted you, she took your keys and left. Is that right?
Yes.
Did you give her permission to take your car?
No.
Does she normally drive your car?
Every once in a while, but in this case, she didn't have permission to take a vehicle.
Okay. Do you have any idea what was in your phone that got her so upset?
It was probably
I don't want you to speculate. Say probably. Did you have something in your phone that would make her upset?
Yes, I did.
What did you have?
It was a picture of my friend holding our possible son.
So at the time that you were being assaulted, did the defendant mention anything about why she was assaulted? Did she say anything?
It was something about that, yes.
Okay. Mr. Cripps asked you about refusing EMS. You say you went to the hospital, right?
Yes.
How did you get there?
I had got there through my father.
The father took you?
Yes.
So when the police came, did they offer you, ask you, did you want EMS to take you to the hospital?
They had offered the EMS, but my father had stepped up and told me that he was going to take it.
Okay. Any questions based on my question?
No questions.
No.
Thank you, sir. You may step down. Any other witnesses for the people?
Your Honor, at this time, the people would call Jay Johnson.
Give me an offer of proof as to what Mr. Johnson is going to testify to.
The pictures that this complainant indicated that his father had pictures of him that night that were on his phone. The complainant testified that the defendant had his phone and took pictures of him. The complainant testified that he gave those pictures, so sent those pictures to his father. So his father has them on his phone. And his father can also testify to the injuries that he saw, if any, that night.
Well, we object to this, we haven't received that.
And I don't have them. I don't have them either. The father came today and he told me that he had pictures. I don't have them either.
Well, this is not a discovery deposition. It's not fair to the defense to all of a sudden come forward, or the prosecution either, with these photos brand new that none of us have seen. So I'm objecting to the commission.
All right, I'm going to err on the side of caution. I'm going to sustain that objection. If it's necessary. Okay. Sorry for dragging you in here for no reason, sir. Good to see you, though. Appreciate you. But I understand you have some information that you're gonna want to share with the prosecutor, so she can share that with the defense in case it's needed later. Okay. Okay. All right. Thank you.
All right, thank you, Judge. And with that, I have no further witnesses.
No witnesses on behalf of the defense, Your Honor.
Okay.
Your Honor, at this time, I would move to bind over on all counts.
Thank you, Your Honor. Well, we strongly would object to bind over on the felonious assault felony firearm. Now, we have circumstances here where obviously she's at home. She's at her own home. He comes over. That sounds like at her invitation. They're in bed together. He falls asleep. She wakes up. He wakes up, and then she's obviously physically striking him. We heard that in great detail. Towards the conclusion of it, there's a firearm. The firearm is at least 20 feet away from her, according to the defendant's testimony. And she points at it. So it's not as if she grabs the rifle and points at him with it. She points.
I thought that's what the testimony was. She pointed at it.
No, as I heard it, she pointed at the rifle that was standing in the corner, and that's when she made those threats.
Totally misunderstood that. You said she pointed at the rifle?
That's how I heard it, Judge. She pointed with it.
Let's get some clarification. I think the witness is still here. Let's have this. I need to get that clarification. That's totally different.
Because she testified, he testified she was some 15, 20 feet away when she was pointing at the rifle. Pointing to the rifle and said, "You don't know what I can do to you." Again, because the rifle is so far away, it's not approximate grabbing distance.
Okay, we'll see.
I do agree. I do agree with that.
That he pointed at the weapon? That she pointed at the weapon?
She pointed at it, and it was by the door, and she pointed at it.
That's the way I heard it too.
Okay. Sir, I just wanted to get some clarification about the rifle that you testified about. Did she ever gain control of that weapon and point it at you?
She had control of it, but she never put the weapon in.
She never pointed it at you. Okay. All right. I'm glad you brought that up because I misunderstood.
Thank you, Your Honor. So that's my argument as to the felonious assault felony firearm. We would ask that the felonious assault and the felony firearm count be dismissed. As to the unlawfully driving away, it's entirely circumstantial, but I think falls short of probable cause. He says she took the keys, and then she got it, claimed that the vehicle was then missing. So again, we can't say for sure that she actually left the vehicle. But if you were to conclude that under the circumstances that the car was missing shortly after she took the keys, he said that she commonly used his vehicle. So we have an ongoing, I guess, implied consent that she could use the vehicle because he said that she commonly did. So in her mind, there's no showing that there was that she willfully or without authority took the possession and drove away the vehicle, because I think you can infer that she had to apply permission to take a vehicle because of past use of by his own admission.
Your Honor, I would state that as to the vehicle, he specifically stated he did not give her permission to take it at night.
This is after he has been assaulted.
Absolutely. he says she not only took the vehicle, but took his phone. He had to walk places to try to get help or make a call just to get help. In regards to the felonious assault and felony firearm, I would just indicate that he, after being beaten multiple times and having to get medical attention, he states that she pointed to the gun and made a statement. You don't know what I can do to you.
This sounds pretty conditional, doesn't it?
It
Not
does.
that I'm going to get this and I'm going to do anything, so it doesn't sound like the threat was imminent.
Yeah, and it was a ways away, and she did take it, from the testimony, she did take it with her. I have no further.
All right, as it relates to count one, assault with a dangerous weapon, the people have to establish on this record that the defendant was put in fear or apprehension of immediate battery or with a dangerous weapon. It doesn't sound like there was any imminent danger here. In fact, the weapon was allegedly some distance away from her and she pointed at it. Unlike what I thought I heard, I thought she pointed it at him, which is not the case. The court is not satisfied that people have met their burden of probable cause as it relates to count one, assault with a dangerous weapon, or the accompanying felony firearm. The court is, however, satisfied that people have met their burden of probable cause as it relates to count two, unlawful driving away motor vehicle, and count four, domestic violence will go over as well. The witness indicated that after being assaulted, the defendant allegedly took his keys and left them home. He looked outside, she was gone, the keys were gone, and the vehicle was gone. And he did not give her permission to take the vehicle. So the court finds that people have met their burden of probable cause as it relates to count two and four. The court will therefore find the defendant over to Wayne County Third Circuit Court Criminal Division for the proceedings. Information date, time will be May 1st, 2023 at 9 o'clock a.m. Will be continued.
Thank you very much.
Thank you. He said she pinned me down like a. I chewed up the inside of my mouth to keep laughing me down.
I decided not to go into talk. I'm not sure about the rest of the groups.
You guys gotta learn how to lock their phones.
Right. Well, I've heard some people, you can do fingerprint.
Oh, yeah.
I've heard people take fingers and put them on the phone, you go out. How about not have stuff with the phone on?
Right.
Did you do a dismissal for counts 1 and 3 from me?
Yes, Your Honor.
Okay. Martez Johnson.
Mr. Johnson.
Calling case 2356182 for the state of Michigan versus Martez Johnson. Defendant is charged in count 1, weapons, firearms, possession by a felon. Count 2, assault with a dangerous weapon. Count 3, felony firearm. Count 4, felony firearm. Count 5, domestic violence. Defendant has an additional offense before defense service. Appearances for the record.
Good morning, Your Honor. Shelley here for the people, P number 60249.
Good morning, Your Honor. Neighborhood Defender Service by Summers Brush, number 85828. Appearing on behalf of Martez Johnson, who is present today. Mr. Johnson, please state your name for the record.
Today is the date and time set for preliminary examination. Are we ready to proceed?
Oh, I'm sorry. Yeah, it's 85828.
Yes, Judge, I am prepared to proceed.
How many witnesses will there be?
Just one, Your Honor.
Call your witness, please.
Your Honor, at the time, the people will call Lakia Thompson.
Yes. Good morning, ma'am. Please step forward, give your name and the spelling of your name to the young lady seated over here. Please raise your right hand. Swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God. Thank you. Please have a seat in the witness box next to me. Keep your voice up nice and loud and speak into that microphone to see the record, okay? You may begin when you're ready.
Thank you. Good morning. Please state your name once again for the record. Lakia Thompson. All right, Ms. Thompson, I'm going to be asking you some questions. If you don't understand something, or if you want me to repeat it, please let me know, all right? Okay, thank you. All right, Ms. Thompson, I want to bring your attention back to the date of March 25th of this year, 2023. Do you remember that date? Okay, and where were you on that date? And where is your home located? All right, is that in the city of Detroit and County Lane? Okay.
Ma'am, if you'd like, you can remove your mask so we can hear you. Speaking to the microphone.
Yes, ma'am. Okay, and when you were home on that day, were you home alone or were you with anyone else? Okay, you were with your kid's father. What is your children's father's name?
What about
Martez Johnson. All right, and do you see Mr. Martez Johnson in the courtroom here today? Yes. Okay, just for identification purposes, I would like to ask you where he is in the courtroom and what he's wearing today. Thank you. Your Honor, please, with this record reflects this witness has identified the defendant, Martez Johnson.
what color t-shirt? I'm sorry.
Black.
Black, okay. So noted.
Thank you. All right, and so was it just yourself and Mr. Johnson? Yes, ma'am. Okay. And what happened that night there then? That morning? Oh, I got off work. I worked in nights. I got off came down to work. Mr. Johnson? Mr. Johnson came down to work. Okay. Went to my home. It was already like my attention going on at the time. And why was there tension? Many reasons, honestly. I allowed him because I had been overworked. I lost my job back in November. I had 3 children. I was working odd jobs before I recently got the job that I have now. So he was over helping me care for watching the kids while I was at work. That morning, like I said,
a lot of tension went on already because like 3, 4 days in a row, my kitchen was nasty, like I worked 12-hour shifts, you know, just a little help around the house with the kids. You know, so it was, like I said, a lot of tension already. So I come to the house, I had an attitude. Well, I was in and out of sleep in the car, I was tired at work. Came to the house, just really had an attitude, house is still the same one. So he kept asking me what was wrong, he noticed something was wrong with me. Kept saying nothing to diffuse the problem. It made him angry, I guess, because I kept saying nothing. So tension started rising, I was yelling, he was disrespecting me. Like I said, I kept saying nothing. I went to run some mail for it, because I wanted to get him to. It was very aggressive again, because like he was just, you know, bitch this and I'm tired and this and that. And I wasn't, you know, responding at the time or whatever.
Okay, let me stop you for just a second. Okay, so there's more tension going on, is this what you're saying?
Yes.
Okay, and you wanted to take a bath?
I was preparing a bath.
Okay, so what did you do to prepare for the bath?
I ran some bath water in the bathroom. So I was in the bathroom, he was in the hall, in the front room, but you know, he's still going on and on.
Do you think he's talking?
Yes.
Saying?
Yes.
What is he saying? Do you remember?
It was a lot more, you know, bitch, I'm tired of you, and excuse my language, it's okay. He told me I was miserable, and, you know, just, it was just a lot, like.
Are you responding at all at this time?
No, like, I wasn't saying anything.
Oh, okay. I said, are you responding at all at this time?
No. No.
Okay, so what happened next?
So he stormed to the bathroom, I had the door closed.
So you're in the bathroom, the door is closed?
Yes.
Okay, and how did he get in?
Pushed open the bathroom door.
Okay.
And it was like everything kind of went so fast, like he grabbed me and like had choked me up around my neck.
Okay, let me stop right there.
Okay.
He grabbed you?
Yes.
Okay, what did he grab you with?
He put his hands around my neck.
Okay, he put his hand,
Like
both
my
hands?
collar, yes.
Okay.
I had bruises and everything. The detectives did take pictures, the one that I called out the next day. Because I didn't report that assault the day that it happened. He told me that he preferred that I did not.
Okay, just take a minute, take some deep breaths, and just let us know when you're ready.
He was making a lot of threats at the time.
Can I ask you what kind of threats?
He told me when he didn't suggest that I went to the where I was running because he was drowning me. He was just really angry.
He said he would drown you in the bathwater?
Yes.
Now let me go back to his hands were around your neck. Is that right?
Yes. Okay. So the drowning incident, the comment that he made was before.
Okay. So you're in the bathroom, and he says he's not going to suggest you
run the bathwater because he was drowning.
Okay. What did you do at that time, if anything?
The water was still continuing to run. He walked out of the bathroom. I didn't follow him, but I kind of followed him because at that time he intended to make another threat. He had a gun in my closet. He went and grabbed the gun, told me he was going to pistol with me.
Okay, so I want to back up just for a minute. When he had his hands around your neck, okay, did he just lay his hands on you, or
it was really quick? Like it wasn't like a choke, like he choked me, but it was like really quick. I went up against the wall and he let me go.
Okay, you said you had bruises?
Yeah, it was like a slight scratch here. This part of my neck has swollen up and I had like a red bruise up here.
Okay, so you're saying your breathing wasn't restricted?
No, like
It wasn't
nothing,
like
no,
that?
he didn't like choke me and he didn't hold me for a very long time. And I said it happened like really bad.
Okay,
But the bruises came like really good.
okay, all right. So then he leaves and what are you saying about a gun?
He walked out the bathroom and told me that he was gonna pistol with me. At this time, I'm standing in my hallway, he in my bedroom. When he took the bottom of the gun out, tossed it on my bed.
Where was the gun?
It was in my closet.
Okay, whose was that?
It wasn't mine.
Okay. All right, and so he took the gun?
Took the clip out.
He took the clip out, okay.
Took the clip out. He did something with the top of the gun. I don't know, something that came out on the top of it. And at that point, as he was coming towards me, I traced my arms. And I like held his arms, but at this point, it's like, I'm not about to allow you to attempt to take me. I guess I'm very terrified of him when he gets very aggressive and I showed up a lot to where it's like, I don't talk, I don't, I'm just, I don't want to deal with it anymore. So again, I show up, but when I get that, it does something to me too. It's just something.
Okay, so what happened with the gun?
He put it away, like it went from a really, really crazy argument to it kind of calmed down to it was like talking, it was still like, a little tension in between, but we're having a conversation at this point. I'm sitting in the bathroom on the toilet, he's in front of my daughter's room door, and like it's in between my phone and my living room, because they have to go to the living room. And like I said, we're talking, kind of calmed down a little bit, and I got up out the bathroom, and again, like we never stopped talking, we're still talking. I went, because at this point, the conversation was kind of more in a reflect of how I felt at this point. So, I'm a little aggressive, I'm yelling, I never want to lay hands or make it hurt or whatever. And he's in my living room and I'm standing up in my doorway. And he fucked this spit in my face and told me how much he hated me repeatedly. And
just take your time.
I was so I ran to the bathroom. I looked in the mirror, I see the spit on my face, I wiped it off, and I'm just crying. Because at that point, it was like, wow, like you really fit in my face. I felt so degraded at that point. It's like all this because I don't want to talk. All this because I'm trying to confuse because for years, like, ma'am, we've been in a 16-year relationship with 3 kids. It's very toxic. The last 2 years we have not been in a relationship though. It's been another altercation leading up to that. So again, like feeling like I can help him because he's helping me again. He is the father to my 3 kids. And I just feel like a lot of things were turned malicious because it's like, you don't care about my livelihood. I could get put out of where I'm staying at because I'm allowing you to come. You know what I'm saying? It's my livelihood. Yeah, just trying to help you. And every chance you get is me. It's always F me, F me, F me. It's like, I'm tired.
Okay, I understand. Did you eventually make a report about what happened?
Okay, so after the incident, I went and laid down. I did not get the bath water. I went and laid down. My mind was racing in there, so I put my clothes on, and it was raining today. I went and walked to the park, crying in the ocean. I sat there for probably about an hour. He texted me. He texted me. Said mentally he hated me, but he loved him wholeheartedly.
I just asked if the witness respond to this. I'm sorry, a specific question. I'd ask if the witness respond to Ms. Grant's specific question about climate.
Okay, so after that, I walked to her. Thank you. I came back home. At that point, we didn't have too many words because I think it was more to the conversation. He was supposed to have been leaving to go out of town at the beginning of the month. So it was like, don't talk to me, don't speak to me. So I was on those terms and not talking and speaking. So that day had went on.
Okay, let me just ask, did you make a police report?
Yes, the next day.
You made a police report the next day, yes. Okay, all right. And I just have just a couple other questions about the gun. I just want to make sure I clearly understand. You said he got the gun, and then you said you then restrained him.
He took the gun out of my closet, took it out. He told me he was going to pistol me with me, he took the gun. When I seen him walking towards me with the gun, I restrained him.
And why did you do that?
Because I wasn't about to allow him to attempt to hit me.
Okay, so he walked toward you with the gun, he threatened to pistol with you, and you stabbed him with it.
Yes.
Okay, all right, thank you. I have no further questions at this time.
Cross examine.
Hold on, wait.
Counsel, you're gonna have to speak up to the first she's way over there.
I apologize.
Right. Good morning, Ms. Thompson. How are you? So you testified that you've known Mr. Johnson for a while, correct?
Yes, ma'am.
You share children.
Yes, ma'am.
You share 3 children.
Yes, ma'am.
And so he was staying at your home at the time.
Yes.
How long have you been staying there?
He would come over, we originally made an agreement to where it was spoken that he would move in, probably a month prior. February. But he had been at my house again, helping me with my children since about December.
So he was helping with the children.
Yeah, just watching the kids.
Okay, and helping around the house.
Yes and no.
So, and that's what caused some of the tension, right? You were frustrated that he wasn't helping as much as you would have liked.
Yes, ma'am.
And so then you would come home from work and be frustrated. Okay. And Mr. Johnson would drive you to work, right?
On Sunday.
Okay.
I would take my car Sunday to drop me off.
So what time does your shift start?
I work from 6 p.m. to 6 a.m.
Okay. Was that evening you testified that you had just gotten back from work?
That morning.
That morning, so it was early in the morning. Okay. And that's when you were frustrated once again, right? Because the kitchen was dirty. You testified to.
Yes.
And so that's what began the verbal dispute.
Yeah, because he sensed something's wrong in my facial expressions, I guess, to let him know that I had an issue.
Okay. And so you were arguing in the bathroom, right?
Well, it wasn't an argument.
Or, I apologize. So he was yelling at you in the bathroom.
Yes, ma'am.
Yeah. And you testified that he told you not to go in the bathroom water, the bath water.
Yes, ma'am.
And you never went in the bath, correct? Okay. And you also testified that one moment. And you never needed medical attention for the incident, right?
No.
Okay. You never went to the hospital or anything?
No.
Okay. And you didn't call 911 that morning?
No, not the day of it.
Things sort of diffused between you two.
I mean, if you say me not talking, like me walking around my house, me not having a conversation with you.
And after the argument had ended, did Mr. Johnson move his things into the basement?
Okay,
Correct.
so I was asleep. I wound up going to sleep. So in the midst of all that happening, I was asleep. I woke up and noticed because he was on my couch at 4 minutes. He wasn't in the bedroom together, anything, whatever. So he had been on my couch. But yeah, when I woke up that, afternoon, morning, whatever time I was not up, yes, I noticed that he had moved all the things that belonged to him in my basement.
Okay, so this was ostensibly to create some separation between you two.
I guess so.
Because of the
She can't
tension.
testify as to what the motives are. She
Understood.
testifies to what took place.
Understood, Your Honor. I've tracked that. And so let's transition to March 26th. After the morning of March 25th, you didn't call. Actually, let's go back. So you had a shift later that day on March 25th.
Yes, that Saturday I moved back to work. Yes.
Okay, and Mr. Johnson did he drive you to work that day?
Yes.
So things had diffused to the point where you were alone in a car with him.
Yeah, his attitude had calmed down, but again, there was still no conversation, no anything.
Understood.
Well, it was a slight conversation because he did text me and ask me, would he be taking me to work? He didn't know like I was on the catch the bus, but besides that, in a text message, there was no conversation, no communication.
Okay. And so he drove you to work?
Yes.
And, oh, sorry, go ahead.
No, he drove me to work, dropped me off, came back and picked me up.
Oh, and he picked you up as well? Okay. And so then it wasn't until the evening of March 26th that you called?
Yes.
The
So,
police?
I was in my room. My kids were at his mother's house, and
Can I stop right there? So your room is on, what, is it on the first floor?
It's on the main floor.
It's on the main floor, okay. And Mr. Johnson then was staying in the basement, right?
Yes.
One floor below?
Yes.
So the staircase separating you?
Yeah.
Okay. And so then it wasn't until that evening when you decided to call the police?
Yeah, so like I said, again, there was no communication between us. He did message, well, he had texted me, told me to go get my kids from his mom's house.
Okay, so at what point did you call the police?
Okay, so he came back in the house, because he came to my bedroom, and I always keep my cover over my head. So he came and said something to me, I didn't respond. He left, he came back probably 15, 20 minutes later, said something to me again. I responded at that point. When I responded, he closed my room door. He went downstairs in the basement, and I like through the vent, because where he was at is like above my bedroom, and he was just like, nah, you're not gonna.
Okay, so let me stop you. So were there dogs? You had dogs, right?
Just his dogs.
His dogs, and they were with him, correct?
I mean, they were in the bed, they in a separate room, but I wasn't downstairs, so I can't say if he had them out or if they were in the room where they're normally.
Okay, and so it was when you heard him through the vent
Yes.
talking in the basement. That's when you left the house.
Yes.
And you called the police.
Yes.
And that's when you filed a police report.
Yes.
Okay. One moment, Your Honor. No further questions.
Any redirect?
No further.
Thank you, ma'am. You may sit. Any other witnesses for the people?
I have no further witnesses.
Any witnesses for the defendant?
No, Your Honor.
People?
Your Honor, at this time.
Oh, you know what? Can you have us step back in just for a second? I do have a question for you. My apologies, ma'am. Let me remind you that you're still under oath, okay? I want to know a little bit more about this choking incident. You say he put his hands around your throat. When he did that, were you still able to breathe normally as you do at the time you did that?
He wasn't like up here, he was also here.
So it was on your chest and not your throat.
Yeah, I mean, his arms, like I said, he wasn't like all the way my front here, but I had bruises here, And he was here, so it's more so like he,
So the witness is indicating bruises around her right collarbone,
yeah.
left collarbone.
Like the scratch there, this dude, it was like, it was pretty much like the hickey, because it was like really red, this was like anything.
So he didn't choke.
No, it wasn't like the physical.
Okay, I just want to clear that up. Thank you. Any questions based on my questions?
No, Judge.
All right.
And Your Honor, at this time, I would present to the court as to count one, weapons, firearm, felons in possession. I do have a certified copy of a prior conviction of the defendant, Martez Johnson, that on March 2nd of 2011, he was sentenced for the offense of carrying concealed weapons. And that would go to count one.
Admitted.
Thank you. And Your Honor, as to the rest of the counts, I would ask, I would move to bind over on all the rest of the counts, and I would reserve argument at this time.
Or as to the felon in possession charge, I argue that the people have not met the burden of probable cause that for a felon in possession of a weapon. We have Ms. Thompson's testimony about the gun, but that gun was never admitted into evidence in any way. We don't have a police officer to testify about the nature of that gun, about who it was registered to. The police officer.
Registration doesn't mean anything. You can possess something without having it registered to you, right?
Understood, Your Honor, but I'd argue that when you're since Mr. Johnson is being alleged of having this physical evidence in his possession.
So you wanted the people to bring the gun in?
No, but testimony from officers who arrested him about whether they found a weapon on the property, something, any evidence that shows that that weapon actually
You recognize
existed.
that the witness that testified, her testimony is evidence, right?
I do recognize that, Your Honor.
So why should not believe that evidence?
I'd argue that that's not enough here because it's we need more that this gun exists.
Why do I need more?
Because we need an evidence tag number. We need if this were to go to trial, I'd argue that.
You recognize this isn't a trial, this is probably.
I do, Judge. I do. Yes. I'd rest on my argument for that count. And then as for the assault with a dangerous weapon, I would argue that that charge is a question of fact with the trier of fact. The witness did testify that they got into a verbal dispute, that things were tense between the two of them, and I believe that testimony is a question of fact.
Okay, so I'm a little confused by your argument. If count two is a question of fact,
So
assault with a dangerous weapon, then you're acknowledging that there's probable cause that he assaulted her with a weapon. That how could count one not also be a question of fact, because the weapon that was used was a gun, so he would be a felon in possession of that weapon. The same weapon that you acknowledge that there's probable cause to bind over on assault with a dangerous weapon.
Yes, Your Honor, I apologize. I misstated. I had read the information wrong. So I would also rest on my argument that there's not enough evidence here that Mr. Johnson was ever in possession of a weapon. Thank you. And then I don't know if the prosecution is intending on, well, never mind. I rest my case here.
Right.
Your Honor, I would just indicate that I think it was very clear from the witness's testimony that they had just had a physical altercation in the bathroom, And now she testifies that the defendant then got a gun out of the closet. She saw him with it in his hands. He stated that he would pistol with her. She did not want that to happen, and she restrained him before he was able to do so. I believe that her testimony was credible and believable as to what happened on that day. And again, I need to find over on all counts.
All right, so the witness, Lakia Thompson, testified here. And the court found her to be a very credible witness. I believe every word that she said, particularly about the defendant spitting in her face, which is probably one of the most degrading things that someone can do to another human being. It's just plain nasty. But I believe her when she says that the defendant assaulted her. This defendant also assaulted her with the gun. I found her testimony to be very credible. The court, after hearing the testimony of Lakia Thompson, is satisfied that the burden of probable cause as it relates to all the charges contained in the complaint. Let me also add that if I believe the witness sworn testimony, which is evidence, that is enough for not only a bind, but for a conviction. If we believe that evidence is credible. I don't need any supporting evidence if I believe that evidence, which I do. The court finding those charges were committed in the city of Detroit, and the court finding probable cause to believe this defendant committed them, will bind the defendant over to Wayne County Third Circuit Court Criminal Division for further proceedings. His arraignment on the information date and time will be May 1st, 2023 at 9:00 a.m. Are there any issues as to bond? Bond will be continued. Do you understand, sir? You are to have no contact whatsoever with the complaining witness, right?
Oh, Judge, if I could address one matter, Mr. Johnson, as you know, that he was living with Ms. Thompson at the time. He has not been able to get any of his belongings, any of his clothing, since he's released from custody. I'm wondering if there's some arrangement we can make for an order for him specifically to get just his.
I'll leave that up to you, the prosecution, to work that out. I'm not going to get in the middle of any property issues. Okay, but you understand what I mean by no contact, right?
Yeah, I can't even see the kids.
No contact means no contact. If you don't understand, I can make it to where I am assured that you don't have any contact. I'll put you in. When I say no contact, that's exactly what I mean. And that's condition of your bond. No contact, no phone contact, no contact from a third party unless you guys can stipulate that you're able to get certain things, items from her or that location. Okay?
Just wait a moment.
So next case, not to change it.
No, it's on, but they don't have it. Oh. Right. So, you come here. Right, because they supposed to check in the thing out there. They don't have a hook. Yeah, all part of it. But they don't have a hook up yet. So. Maybe it is. Yeah, maybe it is a document. I don't know. Yeah, but they have. People, they got. Yeah, I wonder if this would be. Sure. Nobody might get us. Yeah, it might be a check. Check.
How you doing there, Mr. Kenneth?
Oh, good. How you doing, Judge King?
Good, what's up?
Judge, I have an exam at 1:30. I talked to Shelley Drain. She said it's going to be a dismissable. I can't even talk. A dismissal. I was wondering if I could Zoom on or if you would prefer me there. I will do whatever the court wants.
It's gonna be a dismissal, you can zoom in.
Okay, thank you, sir.
Not a problem.
Okay, bye-bye.
It's okay, guys. 1:30. I think 12:30 going away too.
I'm not sure about your 12:15. Your 12:15. My phone says he's in, what it say, Saginaw County Jail. So if they didn't read him out,
Which one's that? Not sure.
on Joshua Johnson.
Okay, you need to come? Oh, you don't have to. Okay.
See the regular speed. This is repair speed. Yes.
Oh, they are. They know I say nothing at the front door. No.
Very fast.
Oh, okay.
Is this called Judge Knox? So you have to-
No.
That's in this afternoon.
They got they on the 11:45 case of 250 cases.
You got somebody else? You got somebody else?
I guess, Judge Jefferson.
Oh, so they I recall.
That's my private voice.
Everybody here for 12:15?
What is it? We're waiting on the attorney. The defendant is downstairs and locked up.
Oh, they brought me.
That's Mr. Gunsey.
What about,
Johnson,
Still no Johnson?
still no Johnson. He's not even in jail, so they probably didn't rid him out.
Okay, let's have Mr. Hunter come in.
Okay.
See what it's ready.
He was in that.
Okay. It looks like this. Oh. Okay, so you got some references. So it's set for probable cause.
Come on in, Rita, make yourself at home. Ready? Sure.
Okay. Good morning. Hello, how are you? Okay.
Hey, Anita, you still expecting me? Attorney Johnson. You can come out, sir, have a seat. You'll go through that small door right here. Walk to the.
Jalen Gunter. Calling case 2261105, the state of Michigan versus Jalen Gunter. Defendant is charged in count 1 assault with a dangerous weapon, count 2 aggravated assault, count 3 domestic violence. Appearances for the record.
Good afternoon, Your Honor. Shelley Drake for the people, key number 60249.
And good afternoon, Your Honor. Rita White on behalf of Mr. Jalen Gunter, who's standing to my left. My P number is 63046. Please state your name, Mr. Gunter.
There's date and time set for preliminary examination. Are you ready to proceed?
Yes, Your Honor.
How many witnesses for the people?
I just have one witness, Your Honor.
Ready to call your witness?
Your Honor, I have had a chance to speak with Mr. Gunter about the nature of a preliminary examination and the purpose. And at this moment, he would like to waive the exam and proceed with this matter.
Mr. Gunter, please raise your right hand. The other way. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you, sir. You understand you have a statutory right to have a preliminary examination. By waiving the same, that means you won't have one, and you'll be bound over to Wayne County Third Circuit Court as you stand charged with complaint. You understand it? Speak up for me. Yes. You understand the nature and the purpose of the preliminary examination? Yes. You understand if you were to have one, the prosecution would have to establish that the crime you're charged with was committed in the city of Detroit, and if there's probable cause to believe you committed it? Yes. Is anyone forcing you to waive your right? Does anyone promise you anything? No. Are you waiving your right freely and voluntarily? Yes. Any objection from the people?
No objection, Your Honor.
The court finds the defendant's waiver is made knowingly and voluntarily, freely given. The court finds the defendant over to the Wayne County Third Circuit Court Criminal Division for proceedings. His arraignment on the information date and time will be April 24th, 2023 at 9 o'clock a.m.
Your Honor, I did want to inquire whether the court would be open to readdressing bond.
Readdressing bond, so bond has been addressed before.
Yes, Your Honor, he did have his PCC back on April 10th, which I did request a lowered bond. I believe you did order a DSU. However, there was already a DSU in place, but I was looking to have an updated DSU or have it done.
So you want to update it? Yeah, so what's changed between last time and now?
Well, the fact is that he was seriously assaulted in the jail, and he has mental health issues that he really needs treatment. I did speak with his mother. I've been in regular contact with his mother, who has already set up his protocol for he does have an appointment or had an appointment scheduled, which I still believe is active, to meet with his therapist to maintain his treatment. His mother is very involved with his care, and given the fact that he's a first-time alleged offender, he's basically under the age of 20. He's 21, correct? 21 years old, no prior criminal history. He is very aware that no contact will be put in place for him to not have contact with the complainant or any other witnesses or victims involved in his cases. We were requesting a reduced bond, not necessarily even a personal bond, but I believe we would ask that it be at the most, at the reduced down to 100,000 cash surety.
How far did you go to school, sir?
I'm in 12th grade.
Graduate?
I was still in school.
How old are you?
21.
So you're 21 in the 12th grade? How does that happen?
Because I was in the step-up program, I learned slow.
Within special education?
Yes.
You do anything else besides go to school?
I had a job. I was working with my uncle. We had a little landscape company. It's called Jones for Change.
What school were you attending?
It was called the Step Up Program.
That's the name of the school?
It's a program.
So you're not in school?
I am in school. It's just a Step Up program. It's like they give you a computer and you work off the computer, and you have a little teacher that helps you on the side of your phone.
Your Honor, I am going to strongly object to any reduction at this time. I do realize the charges are avoidance assault, aggravated, aggravated assault, domestic violence. However, these charges don't really accurately reflect the brutal nature of what happened to the complainant here.
Tell me about it.
Well, Your Honor, the allegation is that the complainant and defendant got into an argument, and he then said he was going to kill her. She ran to the front door to try to get out. He ran to the front door, didn't let her out, and actually locked the door. He started beating on her. She was able to get to the front door to get out so that she could leave. She ran in the middle of the street and was screaming for help. He ran after her, got her, continued to beat her, dragged her back in the house. She was on her phone the whole time, and she tried to call her grandmother, wasn't able to, but somehow the phone called the grandmother again. Her uncle, I believe, was there at the grandmother's house. She's being continually beaten. She was hit with a shovel on the back. Then the uncle got to the house and was banging on the door. Other people then came to the house. The police came to the house. The sisters then found an open window. The uncle was able to get in the window and get her out of the house. Again, he told her that he was going to kill her. He told her, don't say anything. So the charges don't really accurately reflect what happened.
Sounds like, based on what you said, you got some charges too. Listening to false imprisonment, very minimal.
I think that based on, I'm sure that they did an interview with her, and I'm not sure what they came up with, but in my conversation with her right now, I don't think that it was a very long time period at all, and that's probably why it wasn't charged. But I just wanted the court to know, this wasn't just a little argument and she got hit one time. It was a serious attack on her. So for that reason, Your Honor, I'm asking that there not be any reduction in bond at this time.
What is the bond?
The bond is currently, I have $250,000 cash assured.
You make somebody.
Your Honor, if I may.
I'm sorry.
If I may, just very quickly. Your Honor, as we see, I understand the prosecutor provided information, but we all know allegations are allegations, innocent until proven guilty. My client is very young, and clearly we know what the purpose of a tether is. And the fact that he's already participating in an online schooling program, which he hasn't been able to continue based on being incarcerated. And this is actually a step-up program based in Roseville, but it is an online program that clearly he's showing clearly interest and the goal is basically the direction to continue his education. So I'm respectfully requesting, Your Honor, that he be allowed to be released on the bond amount that I provided to you with cash, with Tether and house arrest.
You said there was a DSU report?
It's going to.
Let me see. Thank you. So according to the court, it says President bond $250,000 cash showing the GPS telephone contact with the victim by regular of weapons. The victim has $50,000 cash showing the GPS telephone contact. So which is
He has on this case, $50,000 cash assurity. My apologies. He has another matter that's $250,000 cash assurity.
oh, he has another case.
Yeah, he
Tell
does.
me about that.
Yeah, I did mention it at the PCC back on the
I mean,
April
today,
10th.
you can't go into what you see weeks ago. I don't remember that. So he has another case.
Yes.
So this bond is 50,000 cash. He was asking for 100,000 cash.
We're asking that you allow him to be released on a lower than $50,000 cash assurity on this matter. Judge Jefferson is handling his other case tomorrow, but I'm just trying to really balance out this bond so his mother can be in a position to be able to make and post it.
So what is the other case?
He is charged on his other case. He is charged with 1 count of armed robbery and count 2 assault with intent to rape out the arm, 2 counts of armed robbery, GBH, and unlawful imprisonment.
Is it involved the same complaint?
No.
So what's the carjacking case from 2021? Sir. Let's see, a carjacking from October 6, 2021, carjacking. armed robbery, unlawful driving by motor vehicle, proceeding, that's what she was just telling me about. Then I also see felonious assault, aggravated assault, domestic violence, robbery, armed assault, to direct out of the crime, robbery not armed. And then this one is a felonious assault, aggravated assault, domestic violence. He has way too much in it. It sounds like a danger to the community, the person.
Thank you, Judge.
Thank you, Judge.
I've seen it.
You want to see Mr. Cooper? Ms. Johnson? And I guess we can do Murray. Okay, let's do Murray. Where's your client, Mr. Bass?
He is here, he's already in the chair.
Oh, is it?
It's strange. He didn't call his son, he was a witness in the past case.
Go ahead, that's it. I didn't realize he drank those.
Anybody know how this happened? I have a homicide scheduled today.
No, but,
It doesn't look like it was a hell of a fire.
I don't know what's going on. They go down Murray. Just sit there.
he not,
Mr. Cooper not off.
nope,
It's not off.
right. Unless he knows something. Maybe he knows that client's still. What'd you say, second him?
I checked it. It's not listing him there.
So, Judge Johnson stepping down. Protein. Ready on Murray?
Ready?
Calling case 2355974, people of the state of Michigan versus LaRon Murray. Defendant is charged in count 1 weapons, firearms, possession by a felon. Count 2 assault with a dangerous weapon. Count 3 and 4 felony firearms. Count 5 domestic violence, second offense. And has an additional offender fourth offense notice. Appearances for the record.
Good afternoon, Your Honor. Shelley Drain for the people, P number 60249.
Good afternoon, Judge, to you and your staff. May I please this honorable report? Justina Shabazz Davenport, P number 82743, appearing on behalf of Mr. LaRon Murray, who is also present in the courtroom, and I am standing in for the attorney of record, Curtis Davenport, with Mr. Murray's permission. Please place your name and record.
LaRon Murray.
This matter is scheduled for preliminary examination at 12:30. Are people ready to proceed?
Yes, Judge.
Shabazz, who has off the record discussion.
Yes, Judge. Defense is actually asking for a dismissal for a failure to not only comply with a discovery order that was already signed last week on February 13th, but also, Judge, for yes, well, I'm gonna just leave it at that with respect to the 14th Amendment due process and equal protection.
Come to the podium and speak, please, so she can pick you up.
Sorry, with due process and equal protection of the law.
Ms. Drain?
Yes, Judge. So this case was refiled. So I had previously sent all of the paper and digital discovery to defense counsel. She did make another discovery request. And specifically, she wanted to get, specifically in an email, she wanted to get the 911 call associated with this. So I did send an email to the email address that we commonly use to get the 911 call associated with this case. I sent that request. I sent that request.
Okay, let's back up for me. You say this was a refund?
Yes, Judge.
Why was it dismissed the first time?
I believe this was the case that the complainant was here. The complainant was here in the witness room the whole time, even before. And there was some miscommunication.
How long have you been asking for this digital discovery?
Oh, Judge, we've been asking for this digital discovery since the inception of the first case. In fact, this case, we were going to be arguing this same motion at that time. However, the complainant at the time failed to appear, so we dismissed it for that reason. However, defense was already prepared to make this same argument back then, because at that time, we had not even received the paper discovery or the digital discovery.
Complaining witness was here.
Right.
So the witness from the was.
Yeah, so we never made this argument. This same argument that I'm making now is actually going to be the argument back in March, on March 15th.
So I'll tell you what I'm going to do. If you are available, Mr. Grant, I'm going to put this over to this Friday, April 11th. If people don't have that discovery to you by that date, or before that date, court is going to dismiss it. Yes. April 21st at 11.
I am available, Judge.
Okay, good. Let's get you here so I can tell her to be here on that date, at that time.
And Judge, while we have the record open also, the discovery
that we do have the videos. The client mentioned having some videos and some pictures. I'm not sure if she already turned over the prosecution, but we would ask for that to also be addressed.
We'll talk to her.
Thank you.
Hi, good afternoon, ma'am. How you doing today? One minute, what's that? Tell me your name for the record.
Patina Evans.
Good afternoon, Ms. Evans. So, Ms. Evans, I can just imagine your frustration. I understand the last time you were here, the court didn't even know you were here. Somebody hid you out of the witness room and didn't let you know about it. So the case got dismissed and was reissued. There's some other things that have to be done before we can proceed in this matter. But I'm ordering that those matters be done immediately.
Okay.
So unfortunately, because of matters beyond our control right now, I'm gonna have to adjourn this case one last time to Friday at 11 o'clock. I'm ordering you to be back on that date and be here a little bit before then. I don't want you mixed up, us thinking you're not here or not coming, okay?
Okay, at what time?
11 o'clock. So
Okay.
be here maybe about 10:40, 10:45, something like that, okay? All right.
And Judge, before she leaves, with regard to the.
Oh, also, I'm hearing that you may have some pictures or video or something like that regarding this incident. Is that true?
I have a video on my phone.
You have a video on your phone
I mean, it's like a recording.
involving this incident?
Yes.
Okay, I want you to show that to the prosecutor so we can get that to the people it needs to go to.
Okay.
Okay?
Thank you, Judge.
All right, thank you.
Just for the record also, defense actually just, filed some motion or just the court and the prosecution motion. One of them being a motion for an evidentiary hearing. I'm not sure if we actually need that, since we are scheduled now for 11 a.m. unless you would like to treat that as for a show cause hearing of the officer in charge or not, to see what is outstanding for the exam. Just wanna.
No, I'm not gonna hold a discovery. We're gonna treat this just what it is, a preliminary examination.
Okay.
So all discovery that's outstanding, you are entitled to make sure you get this train to see what needs to be received from you.
Okay, and Ms. Drainer and myself, we've been in constant communication regarding.
She's
that.
good with it.
Yes. I am too.
I know.
So, okay, thank you.
All right.
Thank you.
Well said, sir. Thank you.
I have some people that are missing. I have Mr. Pope missing. I have Mr. Cooper missing. Roland Johnson, Joshua Johnson. Not sure how a homicide made it to docket today on 12/15. It's a homicide.
That's an example.
That's a competency.
Oh.
So Judge, I think there's just one more thing scheduled at 1:30.
Yes.
So I do know, and I do know that probably, it was done until last Friday, I think afternoon, say that we now know that.
Yeah, Mr. Ghana came in earlier today, he told us.
Oh, okay, okay, good. So, yeah, so is
You
he
want me
just
to get
gonna
rid of him
appear
now?
by Zoom or, I mean,
I told him
however?
he could appear by Zoom.
Okay, I'm gonna just court once they handle that.
Is the defendant in custody? O'Neal?
He is downstairs, Your Honor.
Hi, Mr. O'Neal. Hey, Mr. Polk, how you doing?
I'm good, Judge. How?
All right, so we have a competency hearing with Alexander Armand Smith.
Yes, sir. I apologize. I didn't put it on my calendar. We talked on Friday.
Did you receive a report?
I have not received the report, Judge, but it's my understanding the court has received the report, and I will stipulate to what's been told to me of that report.
Okay.
It's the hints of early on that.
Ready for me? Come on up, sir. Maybe this one right here.
Okay, Mr. Pitts is coming now, Mr. Pope. Okay, Mr. Hitz.
Hey, good afternoon, Judge King.
Good afternoon. Do you have a competency report?
I do.
Okay, we're looking for it. We can't find ours. We're trying to get, what do they find?
They opine that he remains incompetent, but they are hopeful that they can restore competency.
All right, so Mr. Pope,
Yes, sir.
are you prepared to rely on that as well and have the court adjourn it for further treatment?
Yes, I am, Judge, and I just bring to the court's attention, when I spoke to the court on Friday, you did have your copy, so it must just have gotten misplaced because you provided that information to me.
Okay.
Judge, I do have one concern.
What's that?
In the report, they seem to indicate that they believe they have until, I think it was January, I think they might have just said a certain number of months to restore competency. I have the deadline as November 15th of this year. So their deadline's a little bit tighter, or the actual deadline, I believe, is tighter than the Forensic Center believes.
Okay.
And I'm guessing the discrepancy there is the difference between the statute says it runs from the date your order is entered, and I'm guessing they're calculating it from the date he was admitted to the Forensic Center, because there was a gap.
Yes.
All right, so you may want to clear that up with them.
I was planning on contacting them.
Okay.
I have a new report being due by July 10th, so I wouldn't object to setting this for later that week.
All right. Let's call it.
Calling case number 2205-789301. People of the state of Michigan versus Alexander Smith. Defendant is charged in count 1, homicide, murder, first degree premeditated. Count 2, assault with intent to murder. Count 3, reckless driving causing death. Count 4, failure to stop the scene of accident when at fault resulting in death. Count 5, reckless driving causes serious impairment of the body function. Count 6, failure to stop the scene of accident resulting in serious impairment of death. Defendant has a conviction of felony with the motor vehicle advisory.
Appearances for the record, please.
Good afternoon, and may it please this honorable court, APA Jonathan Hitz appearing on behalf of the people, P85288.
Your Honor, may it please this honorable court, Larry Polk on behalf of Alexander Smith. Mr. Smith, would you state your name for the record, please?
Tell us your name, Mr. Smith. Oh, that's not Mr. Smith. He's not here, Mr. Pope.
That's what I thought, Judge, but I could not see. I was like, it would have been the first time that they've ever brought them from treatment to a hearing. Okay, Judge, I'm at this time, I'm prepared to waive his appearance.
All right, the court will waive the defendant's presence. My understanding is that we had a competency report back from the forensic center. They deemed him incompetent to stand trial at this time. However, they feel that they can get him to competency with further treatment. Is that right, Mr. Hicks?
That's my understanding of the report. Yes, Your Honor.
Stipulating to those findings, Mr. Pope?
I am, Judge, yes.
Mr. Hicks?
At this time, yes, Your Honor.
All right, the court makes a finding at this time that the defendant is not competent to stand trial. I refer to further treatment and have a review date for July 13th at 8:30.
Thank you very much, Judge.
Okay, thank you.
Thank you, Your Honor.
Thought Mr. Kenneth would be here by now. Nothing from Mr. Cooper. I think this file was set aside for some reason too. There's something going on with this file.
I'm looking at emails from that.
On Johnson.
That's what this email was saying.
That sounds right. Okay, I'll put it up to what time?
April 25th. Is that gonna be enough time to read them?
Maybe they already did.
Only read on six. Where he said 13. Which doesn't have a date or anything.
Maybe, just maybe, cross their T's.
So we're putting this case on docket for a hearing.
Yes. Next leaves Mr. O'Neill.
Okay, so O'Neill. So we wait on Mr. Gavin.
I didn't have Samuel Smith. So I'm not coming. It's in charge of the retreat in July 13th.
July 13th.
Yes. So did you want to wait on your attorney or you want to get this case dismissed now? You don't need a bond if the case is dismissed. Calling case 2356097, people of the state of Michigan versus Michael Eli Bethel O'Neill. Defendants charged in count 1, assault with intent to great bodily harm, less than murder or by strangulation. Count 2, domestic violence. Defendant has conditional and second offense. Here's for the record, please.
Good afternoon, Your Honor. Shelley Drake for the people, key number 60249.
Tell me your name, sir. There's a date and time set for your examination. Are you ready to proceed?
No, Judge, I'm not prepared to proceed at this time. The complaining witness is a Ms. Tatiana Doloni. She was notified of today's date and time for the hearing. She indicated that she would not be coming to court to testify at this hearing. Therefore, I would not be able to go forward with this case.
That being the case, the court will dismiss this matter without prejudice. So the case is dismissed, sir. We'll probably give release sometime this evening. Appreciate it. Thank you. That completes our docket for today.
We'll have a busy summer this summer, ain't you, with this
Man,
doc?
it seems like you don't.
Man, as soon as it get warm. I know. Man, I knew it was gonna happen, as soon as it get warm.
I did too. Especially with domestic violence cases, those are pretty bad. Or homicides too, unfortunately. To the kill the security guard over the weekend.
I was just in that store the other day too. That's sad. That's sad.
It's really scary. They don't have to do anything.
I know, right? Exactly. They out their way, right?
I gotta be here.
I'll see y'all tomorrow.
All right, guys, be safe. Take care.
Since you want to get Mr. O'Neill.
Oh, yeah, I got to send this part downstairs, yeah. Yeah. No. We got a, knit for the weight, one that, Mr. Thompson, James Thompson.
Thank you. Here.